Good morning, everyone. Why don't we get started? It's 11 o'clock. Thank you for being here on time. And again, hello, everyone. I'm truly glad that you could join us today for this very important discussion using governmental immunities and other risk management strategies to minimize exposure in dangerous conditions, nuisance and trespass cases. Today's topic isn't just legal theory. It's about practical tools we can use to protect our agencies and the public interest. We know claims involving dangerous conditions, nuisance, or trespass can arise from all aspects of our operations, such as lateral leaks, main breaks, sewer backups, or even routine construction projects. And when these events lead to claims, or worse, litigation, our ability to apply governmental immunities and proactive risk management can make the difference between a quickly resolved issue and a costly, drawn-out dispute that affects our agency, our ratepayers, and public trust. Remember, as risk managers, we're not just gatekeepers of claim files. We are partners to legal, engineering, and field staff, helping everyone see how immunity defenses and risk strategies fit together. Thank you for being here, for your commitment to public service, and for bringing an open mind to today's discussion. And with that, let me introduce our speakers. Michael Wenzel is a partner with Bertrand, Fox, Elliott, Osman, and Wenzel. He devotes his practice to representation of public entities. And his practice is focused on defense of cities, counties, water districts, and schools and community college districts in complex litigation matters involving civil rights, employment law, tort liability, dangerous condition of public property, and importantly, inverse condemnation. In his more than 25 years of practice, Mr. Wenzel has defended virtually every type of claim confronted by public entities, including high-profile and high-exposure cases covered in the media. Mr. Wenzel earned his BA degree in History and Economics from Syracuse University in 1992 and his Juris Doctor degree from Rutgers University Camden School of Law in 1995, where he was awarded Dean's List honors. His partner, Amy Leifer Halby, is a partner with Bertrand, Fox, Elliott, Osman, and Wenzel. Ms. Halby represents public entities and their employees in wide variety of cases, including dangerous condition of public property and negligence claims, as well as inverse condemnation claims involving landslides, public improvement disruptions, catastrophic floods and fires, and other natural disasters. Ms. Halby graduated cum laude from San Francisco State University in 2008, earning her BA in Communication Studies and a certificate in Conflict Resolution, with an emphasis on legal and political issues in the United States. She obtained her Juris Doctor degree and the Public Interest Law Certificate with honors from the University of San Francisco School of Law in 2012. Michael, Amy, welcome and thank you for being here. I'm going to turn it over to you.
All right, thank you, Vladimir. Good morning, everyone. Thank you for that introduction. We appreciate the opportunity to talk this morning about some governmental immunities, and I'll start with kind of going over what we're going to cover today. We're going to talk about the most common causes of action that would face public entities, specifically water districts. Going to just touch on inverse condemnation because it's so important to water districts and is so frequently included in lawsuits against water districts. And then we're going to talk about governmental immunities. We'll see how many we can get through. We've got 6 on the agenda for today, and we'll kind of give an overview of these immunities, some case examples, how we've applied them, and then at the conclusion, we will take any questions. So before I get started, I understand this is being recorded. So therefore, I shall make sure to use best practices and inform everybody that the information presented today is for informational purposes only. It should not be construed as any specific legal advice. We're happy to give legal advice in other contexts, but today is not that. So with that, we will get started. And what I'll start with is the common causes of action that water districts face in our experience. And often these types of claims are combined into or combined together in a lawsuit. So we very often see dangerous condition of public property, trespass, and nuisance combined with an inverse condemnation cause of action when there's a flooding event. And not just flooding events, but other, I think Vladimir mentioned, road construction projects is another area where we've seen these claims alleged. And the fact that they're combined creates some unique issues that I'll talk about in terms of why utilize these governmental immunities if you can't get rid of the whole lawsuit. So uh, essentially, in our experience, in almost any case against a public entity involving infrastructure and the failure of infrastructure, failure of a public improvement, the entity is going to be sued for inverse condemnation. And that's true for the sole reason that an inverse condemnation claim is typically strict liability and it allows for recovery of these fees. So we deal with that in almost every one of these types of cases, unless you've got really inexperienced counsel, which maybe 10% of our cases allege something other than inverse condemnation when they should be alleging inverse condemnation. And when that does happen, of course, we let the complaint lie as it is. We don't challenge, for instance, a negligence claim for a broken pipe, because doing so would be counterproductive and educate counsel that if he were to do any even minimal research to understand that he or she should be suing for inverse condemnation. So, but typically most attorneys are going to be suing under inverse condemnation under Article 1, Section 19 of the California Constitution. And inverse comes into play whenever there's a failure of a public improvement that results in damage, typically property damage. So we're talking about water pipes, sewer laterals, flood control channels, road construction projects, could be publicly owned utilities, for instance, provision of electrical services, things of that sort. So those are the most typical cases that we see in our practice. And the important piece of this is that these immunities that are found in the government code, they do not apply to inverse condemnation claims. So you can't get out of the case entirely if inverse is included in the complaint. So our client will be sued for a water main break, let's say, and there'll be inverse condemnation, nuisance, trespass, and dangerous condition of public property. And we may have grounds to try to challenge the complaint, but it's not going to result in dismissal of the inverse condemnation claim. That claim is going to survive no matter what. So that leads to the question is, are these immunities still helpful? And they are still helpful, even in that scenario, for several reasons. First, as I said, inverse condemnation allows for recovery of attorney's fees. And in cases where inverse condemnation is combined with other theories of recovery, the argument is that the plaintiff can only recover attorney's fees expended in pursuit of the inverse condemnation claim. And the law is pretty strong on that. However, in practical terms, it can be hard to differentiate time spent by a plaintiff's attorney on inverse condemnation theories versus time spent on other claims. So a reason to get rid of these claims is because it's these non-inverse claims that are typically far more complex and time consuming to defend. So an example of that would be a case involving a pipe leak of some kind, which would constitute clear liability under an inverse condemnation theory, but not under other theories like dangerous condition or nuisance, where reasonableness is going to come into play. Uh, Questions of how old the pipe in question is, have there been prior breaks, is there a pipeline improvement program in place, are there inspections of pipes? All those issues are highly relevant to claims of dangerous condition or claims of nuisance, but they're not relevant to inverse condemnation. Inverse condemnation is strict liability. You have a failure of a public improvement, and there's nothing for plaintiff to prove other than damages. So if you can eliminate those other claims through application of governmental immunities, it's going to reduce the scope of discovery in the case. It's going to reduce the time necessary to defend the case. It prevents the entity from being put under the microscope in terms of their budgetary planning, in terms of their inspection programs. It could eliminate depositions and certainly extensive written discovery. So it's certainly worthwhile to seek to apply these immunities when applicable. Another issue is that the damages recoverable under inverse condemnation are limited. It's typically limited to real and personal property damages. There's no recovery for pain and suffering, emotional distress, wage loss, things like that. But for instance, in a nuisance case, uh, you can cover for discomfort or annoyance. And it's common in flooding cases uh, to have claims where the plaintiff is saying, I was traumatized as a result of the flooding event. My life was disrupted. Now I live in fear that my house is going to flood again. And they sue for emotional distress. So getting rid of the common law claims, the non-inverse claims, would prevent that. And then you're left with uh, a liability uh, case where you're defending on damages, and it greatly simplifies issues for discovery. It greatly simplifies issues for trial. There's a court trial on liability. I mean, if it's a clear case, you may admit liability and just have a damages phase. So there really is a lot of utility to seeking dismissal of the non-inverse claims. So with that said, we're going to start talking now about the various immunities that you can consider when a case comes in, and I'll turn it over to Amy to talk about natural condition immunity.
Yeah, thanks, Mike. So the first immunity we're going to go over is referred to as the natural condition immunity, and it's found under Government Code Section 831.2. And the specific text of that immunity is as follows: that neither a public entity or a public employee is liable for an injury caused by a natural condition to any unimproved public property, including but not limited to any natural condition of any lake, stream, bay, river, or beach. So with the application of this immunity, it's absolute. And it's going to apply regardless if there was knowledge by the entity or the entity's employee of the condition that gives rise to the incident at issue. It also applies regardless of if there was knowledge of the condition and there was a failure to give a warning about the condition. So it's a pretty broadly applicable condition as long as the requirements are satisfied. So first, there has to be a causal nexus between the condition at issue and either human conduct or artificial improvement. And if there is that found, then the immunity is not going to apply. So this, to say another way, the immunity will apply unless there's an improvement or some kind of human conduct that created, contributed to, or exacerbated the degree of danger that's associated with the natural condition at issue or the condition that led to the incident or plaintiff's injuries. So as you can kind of see from the language of the statute itself, it's pretty fact specific. And we do have some case law, established case law of applying this immunity to specific conditions. We pulled some of these out here, which we thought were the most interesting. But a lot of these complications about the application of the immunity can arise because the terms that natural or unimproved, as they're referenced in the statute, aren't defined. So this can impact the scope of the immunity. And that's why turning to the case law can be helpful to determine whether this immunity would specifically apply to a claim that's come in or a lawsuit that's been filed. So some of the examples that we include here where the immunity has been applied, interestingly enough, in some situations, is a shoreline of a man-made lake was considered natural, even though the lake was artificial itself. Additionally, that the state's ability to control a water level of a man-made lake did not improve the public land. So it still found that it was natural and unimproved and applied the immunity. There's also case law that says the immunity can apply to an artificial reservoir. And just because there's been improvement of some portion of public property doesn't necessarily remove the natural condition immunity from the other unimproved areas of that public property. And lastly, there, in more of a kind of specific application, that a natural condition of unimproved property was found even though there was evidence that a public entity controlled the water level and the flow of water upstream at a public dam. So you can see from these examples that it's pretty specific, and the evidence that needs to be relied on with regard to whether the immunity applies is going to be, the conduct of the entity surrounding the condition and whether it's still considered natural or unimproved. And next, Mike's going to talk about the discretionary immunity. That's another part of the government code.
So next up is Government Code Section 820.2, and this is immunity from lawsuits for activities that involve the exercise of discretion. So under Government Code Section 820.2, a public employee is not liable for an injury resulting from his or her act or omission, where the act or omission was the result of the exercise of discretion vested in him or her, whether or not such discretion is even abused. So the key analysis in application of discretionary immunity is going to be whether the act is part of a planning function as distinct from operational function. So a planning function involves policy decisions as distinct from an operational function that is a lower level decision that is more commonly implementing a basic policy already formulated. So you need to have, for the immunity to apply, some sort of deliberate and considered policy decision where there's a balancing of risks and advantages that takes place to the degree that judicial interference would seem unseemly. So it's important to remember that not all acts requiring a public employee to choose among alternatives entail the use of discretion within the meaning of the government code. So as case law is pretty clear, it's hard to imagine any act taken by a public employee that doesn't involve discretion in some manner in its performance. The example here is even if it involved only the driving of a nail. So I think about a case where there's a decision on how to repair a pipe and how to do the repair, what materials to use, the time frame to do the repair. Those acts all involve some level of discretion, but they don't involve policy decisions. So it's important to hone in on kind of the fact that you need to show more than just somebody thought about something or somebody had to make a decision along the way to exercise some degree of discretion. We're talking about areas of quasi-legislative policymaking, such that there's a reason to avoid judicial interference in how an entity is operating. So there's no basis for immunizing lower level or ministerial decisions, as they're called, for a basic policy already formulated. So I'll give some case examples here on the next slide. In the first case example, this is an unpublished case involving a situation where a landowner brought an action against the county and a water district to recover for flooding of a landowner's house when a retaining wall along the road shifted in the course of construction because of heavy rain that caused a water pipeline to break. So prior to the break, employees had come out to observe the condition of the roadway. They were concerned about the integrity of the pipe because of significant rainfall causing the roadway to sink, and they were concerned it would impact the integrity of the pipe. So the employees located nearby shutoff valves, but made a determination to not close the valves because they thought that the county was overseeing the project and would ensure that no harm came to the pipe. Well, of course, harm came to the pipe, it leaked, a lawsuit ensued, and the water district filed a challenge to the complaint, arguing, among other things, that discretionary immunity should apply to the decision to not to shut off the valves because the employees exercised discretion, which is true. They did exercise discretion, but the court rejected the argument, noting that deciding whether or not to throttle a valve clearly falls on the operational side rather than the planning side. It is incident to the normal functions of a water district. Significantly, the board of directors, primarily responsible for setting policy, does not get involved in such decisions. It's left up to the lower level employees in the field. So the court found that while they respect the fact that every decision involves the exercise of judgment and weighing of alternatives, or at least in this case it did, that it was discretion exercised in the ordinary sense of the word, not with the spirit of the governmental immunity. In another case, and this is the case that we handled, there was a decision to release water from a reservoir in advance of a storm. The plaintiff in this case stored beehives near the banks of a river on private property located downstream from the dam that supplied water. The district operated the dam and in doing so regulated the flow in the river by controlling releases of water to reduce flood impacts. And in anticipation of an atmospheric river that was forecast, the district increased the rate of water release because it wanted to avoid the dam spilling over. And that resulted in localized flooding that destroyed the beehives. So this was a long drawn out litigation. And in that, and this is an example where they only sued under a negligence theory, but we argued that the decision to increase the rate of the water release as a flood control measure and issues and decisions surrounding when to issue public notification in connection with the release were high-level planning functions that required a risk balance of risks and advantages in taking that course of action. And it was a higher level decision making. So in that case, the court granted our motion for summary judgment on other grounds, finding a lack of duty. So never got to the discretionary immunity argument, but we felt it was a strong argument under those particular facts. So it's really going to be case specific, and it's really going to depend on how high level the decision making is. It's not going to apply out in the field to a worker fixing something, but it will apply to more high level decisions.
Another immunity that's kind of comes from that high level at an entity is the officials immunity, which is under government code, again, 820.9. And the language of that says that it applies to city councils, mayors, members of boards of supervisors, governing boards, locally appointed boards, commissions, and elected advisory boards, and notes that they're not vicariously liable for injuries caused by the act or omission of the public entity or advisory board. So some limitations to this immunity that we wanted to flag are that individual officials are not immune for injury caused by their own wrongful conduct. So this immunity wouldn't apply to individual officials who are acting wrongfully in and of themselves. It also doesn't apply or affect, when it is applied, to other public officials that aren't necessarily a part of the boards or committees that are referenced in the specific code section. It also doesn't provide immunity to the board or the public entity themselves. So it's just an immunity that would apply to individual officials, saying that they can't be held responsible for actions of the board or the entity. So there's some limited case law applying this immunity, mostly because the immunity itself, as codified by the government code section, pulled together existing case law at that time regarding public entity officials' vicarious liability for other entity employees. So since it was codified back in the 80s, cases applying it really just hold that individually named board members can't be vicariously liable for the injuries of the acts or omissions of the board. And when this comes up and when it can be applied is in a situation where perhaps the entity itself and or the board of the entity itself is named in a lawsuit. And then there's also an attempt by the plaintiffs to name as defendants individual members of the board. And that's when the immunity would be raised and would be applied to limit the inclusion of those individual officials and have them dismissed from the case.
Okay, next up is firefighting immunity under Government Code Section 850.4. That section provides that neither a public entity nor a public employee acting in the scope of employment is liable for any injury resulting from the condition of fire protection or firefighting equipment or facilities, or for any injury caused in fighting fires. So we don't just represent water districts, we represent all types of public entities, municipalities, and this is an immunity section that is more common in cases involving actual fighting of a fire, but it has applicability to water districts as well in some ways that you might not think if you haven't dealt with the immunity specifically. So the rationale behind the provision is there's adequate incentives to careful maintenance of fire equipment without imposing tort liability, and fire personnel should not be deterred from any action they might desire to take in combating fires by fear that liability might be imposed if a jury believes such action was unreasonable. Courts have found that the meaning of fire protection or firefighting equipment or facilities depends on whether tort liability would likely to have a deterrent effect. In other words, if the equipment involved is primarily fire equipment, such as a fire hydrant, the prospect of tort liability would be likely to affect the public entity's decision about the use and maintenance of fire equipment. So the statute provides immunity for any injury resulting from the condition of such equipment, even if the injury itself is not caused by fire. So I've got some case examples on the next slide. The first one is a case involving the city of Oakland. And in this case, the complaint sought recovery for property damage that resulted from the alleged negligent installation and maintenance of a fire hydrant. And specifically, vandals allegedly turned on the fire hydrant located across the street from the plaintiff's house. The hydrant had its spout pointed towards the street. It directed a stream of water at the house, and it caused damage to the house and its contents. The court found that the city and the municipal utility district were immunized from a cause of action for property damage resulting from the alleged negligent installation and maintenance of the fire hydrant. And that's really the most simple and easy case. A hydrant really serves one purpose in connection with firefighting. So that was an easy decision by the court, I would think. But there are other examples that aren't so clear cut. So example number 2 is a commercial building in the city of Madera that burned. When firefighters arrived at the scene, their fire suppression efforts were hampered by a lack of water. It turns out there was a closed water valve located several blocks away that belonged to the city-owned water system. So the plaintiff sued for damages sustained when the property burned, and the court found that a valve in the city water system used to furnish water to fight fires was part of the city fire protection facilities, thus precluding, by virtue of this government code, recovery for damages resulting from the hampered fire suppression efforts due to the lack of water from the closed valve, even though that valve was several blocks away. So the real inquiry comes down to what if the fire protection pipes also provide water service? And at least the city of Madera case I just talked about kind of implicitly holds that the immunity applies even if the facilities serve both fire protection and non-fire protection purposes. So the water valve several blocks away had more than one function, but it also had the function of supporting fire suppression. So there's another case. This is a 2021 case, Foley versus Alisol Water Corp. And in that case, plaintiff brought an action against the water service company after a water main that ran through a portion of plaintiff's apartment complex ruptured. And Alco had contracted with the developer of the property to install a water main on the property, specifically to comply with the fire marshal's requirements. And the court concluded that the fire protection immunity applied because the record established that fire protection was a substantial or significant factor in the decision to construct and maintain the water main on the property. Evidence was presented that, but for the property's specific fire protection needs, the water main would not exist. Instead, consistent with its usual practice, water would have been delivered to the property's boundary, at which point the developer would have been responsible for installing and maintaining on-site infrastructure. But here there was a specific fire protection requirement for 2 fire hydrants. So they deviated from the usual practice and installed on the property a 12-inch water main designed to meet the flow requirements. So in this case, the court found again that the immunity applied despite the dual purpose of the water pipe. So we've thought about applying this in cases where there's hydrants out in the field, and if they're connected, if there's, for instance, a utility cover that is connected in some way to the fire hydrant, and somebody has an accident as a result of the utility cover being displaced or missing, whether it's in a vehicle, pedestrian, bicycle, if the only purpose that water utility cover provides is in connection with the fire hydrant, then you might have an argument that the firefighting immunity would apply there. So it's really fact specific, but another one to consider.
So the next immunity we're going to talk about is called design immunity. This is found in Government Code Section 830.6. And it's good to note for this immunity that this applies to and involves designs and plans that are made by engineers, not by juries. So it's a good immunity to be used when there are plans or designs of specific projects, so that the immunity can be applied and not have the situation or the case get to a jury. So the language of the statute itself is as follows. It's pretty wordy, as you can see, but generally it states that neither an entity or its employee, public entity or employee, can be liable for injury that's caused by a plan or design of a construction of or an improvement to public property if that plan or design has been approved in advance of the construction or improvement by a body or employee of the entity exercising discretionary authority to give the authority, or where such plan or design is prepared in conformity with standards previously so approved. So to break that down into more digestible bites, the requirements of the application of the immunity are as follows. The first is there needs to be a causal connection. So between the plan or design that's being reviewed or at issue with the immunity and the accident or incident giving rise to the claim or lawsuit. And next, there needs to be approval. So there needs to be discretionary approval of the plan or design that was in place or was given, the approval was given before the construction or the improvement itself started. And then lastly, it has to be reasonable. So there has to be substantial evidence that the plan or design being reviewed was reasonable. It's also overall good to note that the plaintiff's injuries, when you're looking at the causal connection or relationship requirement, what needs to be shown there is that the plaintiff's injuries that they're claiming were caused by a feature that's inherent in the approved plan or design, as opposed to some other cause. So that's really important. But this is also a portion of the application of the immunity that can usually just be established by plaintiff's allegations in their complaint, that's sufficient enough, that there's not too much additional inquiry that needs to go into that requirement. So to look a little more clearly onto the second element regarding approval, the approval has to be authorized by a public body or official. And what needs to be shown is that the plan or design was approved, as we said, before construction by a legislative body of the public entity or some other body or employee exercising discretionary authority to give such approval. There's also the ability to show that the plan or design was prepared in conformity with standards previously so approved. So even if the plan itself that's being reviewed is informal, that might still be able to suffice because there's no requirement that the design has to be in any particular kind of form, and the approval can also be oral. So the example that we've included here is ordinance, a specific city ordinance that delegates authority to the city engineer in this one to make decisions and approve plans. As you can see, it cites to the government code section, so it shows the intention of the entity to be specifically complying with the design immunity. And it goes on to note that the city council specifically delegates its authority to the city's engineer or a designee of the city engineer to approve plans, designs, etc., in order for, as-built plans for the city public work contracts. So that's a good way to show in writing a formal, specific approval of making those discretionary decisions for design immunity. Another example we've included here of when there's the attempted application or inquiry into whether design immunity would apply is a lot of the times what we see in our cases is that reviews of specific as-built is needed. So this is a portion of an as-built that we had for a case, and it shows the typical kind of approval of city plans or entity plans that can be seen. You can see here that it notes the specific recommendation for approval. It has all the signatures from both assistant city engineers, water resource managers, associates, things of that nature, showing specifically that they are approving of the plan and showing that the design and the plan itself are being approved by the entity and them and their designee. The last requirement of design immunity, the last element that needs to be shown, is reasonableness. So this is a very specific evidentiary inquiry. There, in order for the immunity to apply, the entity needs to show substantial evidence that the plan or design or the standards under which the plan or design were prepared could have been adopted by a, quote, reasonable public employee or approved by a reasonable legislative body or other body or employee. So it doesn't need to be perfect. The plan does not need to be perfect. No, devoid of any flaws or issues, anything like that. It just needs to be reasonable under the circumstances. So it's a situational dependent, and the surrounding circumstances related to the plans, the design, etc., are going to need to be reviewed for that. Some commonly held examples of substantial evidence are engineering opinions. So that might be something that's given in the form of a declaration or involvement of different, types of engineers who created the designer plan or approved the designer plan. Another can be the professional standards, if those are applicable to a specific type of bend in a pipe around a curve or something of that nature. And lastly, another can be accident history, whether there's been other similar accidents related to a design or plan that was put in place that can also impact whether the design itself at issue is reasonable.
All right, for the last immunity we're going to discuss today, I'm talking about inspection immunity under Government Code Section 818.6, which provides that a public entity is not liable for injury caused by its failure to make an inspection or by reason of making an inadequate or negligent inspection of any property other than its property, for the purpose of determining whether the property complies with or violates any enactment or contains or constitutes a hazard to health or safety. So the key part of this is other than its property. Unfortunately, otherwise this would be an invaluable immunity, but it doesn't apply to your own property. So you cannot fail to inspect your own property and have something happen and then rely on this immunity. So it typically comes up more in the context of approvals of developments and issuing permits and things like that. But it also can come, I have seen it come up in a case where there was a failure to monitor water quality reports. So under the Health and Safety Code, there was an ordinance or a requirement that water quality be monitored, and a mobile park group of residents sued because the fluoride in the water was too high. They sued the county in that case, arguing that they failed to comply with a mandatory duty, and the county asserted that inspection immunity should insulate it from liability, and the court found that the immunity did not apply in that scenario because the act in question didn't involve an actual inspection of property, of physical property. It involved the reviewing of reports. So where I can envision this most likely applying in the context of a water district is if there was some action or request by the water district to observe some water some facility for the transport of water to a new development, something like that, to ensure something complied with appropriate standards. And if an entity were to undertake that that role for someone else's property, and it turned out the inspection failed to discover something, failed to discover a hazard, or the pipe turned out to be undersized, then inspection immunity would likely immunize the entity from liability for that negligent inspection, or a failure at all to inspect. So the applicability of this provision I'd say, it's going to come up less frequently for a water district as distinct from a general public entity, but it could potentially have application under the scenario I laid out. So those are the key immunities that we most often look to or at in these cases. And it's not an exhaustive list of every immunity that might apply. But before I wrap up, I thought I would just mention that in terms of risk management strategies, it's important at the outset of the case, or even when a claim comes in. Now, no claim is required for inverse condemnation, but often a claim will be submitted in any event to preserve the right to pursue other claims. So at the outset of the case, it's important to look at these immunities and determine whether any of the immunities apply, because if there is a clear immunity, it would be worthwhile at the claim stage to communicate with counsel bringing the claim to let them know that the claim is barred by virtue of one of these immunities, and perhaps the lawsuit can be eliminated in its entirety before it gets going. If not, there's still an opportunity early on when the case is filed to review these immunities to see which might apply, and challenge the case at the very early stages through a demur, or later a summary judgment motion. But it's helpful right at the outset to streamline the case, to reduce exposure, reduce the scope of discovery, and really simplify the case as much as possible. And we have had success with these immunities in cases involving water districts and other public entities. So I encourage everyone to look at it right at the outset and take the time to kind of invest in the research to see if it applies. And with that, we're happy to answer any questions if there are any.
Thank you so much, Mike. Thank you, Amy. Please, as we've asked before, submit your questions in the chat, and we will go over them. Mike, I wanted to ask a question myself, and it's really related to an inverse condemnation. I know that the immunities don't apply to inverse, but there has been some push to try and change that legislatively, possibly. And one of the angles that is being explored is whether a common enemy doctrine used for flood control can also be applied to wildfires, and whether or not that would help with some of the high-profile inverse cases that are presently being filed, for example, related to LA wildfires.
Well, I'm aware of efforts to reduce the impact of inverse condemnation, which I think the name of the case is escaping me now, but it's the seminal, most recent Supreme Court decision on inverse, where it tried to put in a reasonableness standard.
City of Oregon, yeah.
Right, for failure to install a backflow device, which is what I've seen in terms of efforts to kind of lessen the sting of inverse condemnation, given the extreme cost to public entities. I haven't had any fire cases, wildfire cases, I should say. I've had cases involving flood control channels that catch on fire. So I don't have a lot of insight as to the efforts that are being made in that regard, more so on the trying to introduce a reasonableness element into the inverse equation, as there exists for flood control already. But water districts are not in the business of flood control most often, so that immunity escapes them. But for county flood control districts, there is a reasonableness element. I see a push towards trying to bring that to all entities, regardless of whether flood control is at play.
Great, thank you. Chris, I'm going to turn it over to you for questions that we have in the chat.
Donald asks, can you cover the basics of a dangerous condition immunity?
Well, so all of these immunities that we talked about would apply to a dangerous condition claim under 835.2. So we would assert these immunities whether the cause of action is nuisance or negligence or dangerous condition if it applies, and we would argue that it would apply to applies to anything other than inverse. So very useful because dangerous condition is typically combined with inverse, nuisance, and trespass.
Stacy asks, oh, go ahead, Mike.
I was just going to say, obviously, there are unique defenses to dangerous condition involving notice, actual or constructive notice, which is a key element, which is completely absent from an inverse analysis, which is not an immunity, but another defense.
Stacy asks, are there other immunities beyond those covered today that could apply?
There are other immunities. We tried to select the ones most applicable to water districts. Another one that we've seen that I've argued is immunity under Civil Code Section 3482, which says that nothing done or maintained under the express authority of a statute can be declared a nuisance. So that sounds great on the face of it. I mean, there's water codes that allow for the provision of water services, or there's codes that provide for the building of infrastructure. And when that construction project results in disruption to neighboring landowners, they file suit. Or, for instance, if there's an authorization to provide water services and there's a water main break, you would argue, well, we're under the express authority of a statute to provide that water service. We should be immune under the civil code. Unfortunately, it's limited to the delivery of water itself and injuries that flow from it. It doesn't go as far as to immunize any liability that would flow from installation of a water main, for example, a water main that ruptures. So it's a limited immunity, but it's one that we've argued in cases involving infrastructure improvements, for instance, in a city where adjacent property owners are complaining about disruption to their business. And we argue, well, authorization per statute allows us to perform this construction project, and there's going to be a necessary impact that's unavoidable, and therefore civil code immunity should apply.
There's also some other immunities that, obviously, given the particulars of the case, can arise in certain situations. For example, there's dangerous condition of streets due to weather immunity under the government code, or hazardous recreational activities, or trail immunity. So sometimes those can come up, as side issues in cases. And as Mike noted, if we had all the time in the world to talk about immunities today, we might get into those, but we just selected the ones that we thought would be most interesting and helpful for the group today. So just wanted to note those as well.
Next question is, it seems that the courts have been more reluctant to let public agencies out of the cases based on these immunities. Is that something that you can confirm based on your years of practice, or do you feel differently about this?
I haven't noticed anecdotally that there's been any sort of significant change in the mindset of courts. Courts are busy. I think that some of these immunity, it really is going to depend on how fact intensive the inquiry is and whether they're going and what is the harm. Because courts, in my experience, reach the outcome that they want to reach and then work backwards to justify it. And when policy issues are at play, a judge may feel a certain way about a case and find that, and that's when there's moral implications. In the case I talked about earlier with the bees stored along the water, when we underwent a duty analysis in that case, there were things included in that analysis about blame. It's not smart to store your bees right next to the water when you know that there could be a flood and to have no mechanism to remove the bees. So the court looked at moral blame, and I think in my experience, I feel like judges reach the outcome they want to reach and work backwards. But given how busy courts are, I do see receptiveness to these arguments. We've gotten out of cases on trail immunity, hazardous condition immunity, I'm sorry, activities immunity. So we have had success when it's pretty clear that it applies.
Thank you so much, Mike. And just anecdotally on that beehive case, initially the tentative ruling was not in our favor, but we were able to change judges' mind during the actual hearing, which is usually very rare. So we were very proud of that achievement. Again, thank you. It's such a fascinating topic. And as Amy mentioned, we could probably spend hours discussing the other immunities that could potentially apply. I think it was great to hear from you. One other question, the parting question that I wanted to ask is, when is a good time to bring up those immunities in the natural kind of development of the case? What's the most strategic use of those immunities time-wise?
You want to answer that, Amy, or you want
I
me
was
to?
going to say the classic lawyer answer is it depends. I mean,
Okay.
I don't think there's a harm in exploring whether immunities apply even at the claim stage when a claim is presented, because obviously the time and effort can be made there to explore whether there's documentation or recollection of employees or people involved to do some kind of investigation as well and gather documents. And it will depend on the nature of the case. The application of some of these immunities can be a little bit difficult at the pleading stage because that's just going to be based on what plaintiff's allegations are. And I think, well, I was going to say most of the time, but it can really depend. Plaintiffs' counsels are going to be possibly aware of the potential application of immunities and try to plead around such an immunity being at play at the pleading stage. So the potential for a demur or a motion to strike or some other challenge to the complaint itself, might not just be there just based on what plaintiff's allegations are, but it's definitely something that can be raised if the evidence is there to support by way of a motion for summary judgment or adjudication or just discussion for potential resolution before a case gets to trial. But I would say it depends on what facts you have before you, the relationship with the plaintiff's counsel, and what plaintiff specifically alleging.
Great. Okay. Thank you so much, Amy. Mike, Amy, thank you so much. We really appreciate your time, and thank you for educating us on this very valuable and very important topics for us as the risk professionals. We really thank you for everything you have done for us. We will be discussing this in our open forum session in the months of August. So again, thank you everyone for finding time to attend today, to listen to this fascinating discussion. And we will see you in August for our open forum. Thank you, everyone, and have a great day.
Thank you.
Thank you.
Thank you.
Thank you.
Bye-bye.
Bye.
Bye.